Welcome everyone to today's AHLA podcast, where we'll be talking about key trends and developments in healthcare fraud and abuse, compliance and enforcement. There is certainly a lot we could cover in today's podcast, things like recent government initiatives, stark and kickback developments, self-disclosures, changes all across the industry, looking at this past 2023 and also going forward into 2024. We're going to try to focus on a few areas. My guest today is Laura Laemmle-Weidenfeld, and she and I are going to pick a few topics, again, from this list to focus on today. If Laura's name sounds familiar, she recently authored a supplement to her AHLA book titled Legal Issues in Healthcare Fraud and Abuse. She also is a past chair of the Fraud and Abuse Practice Group here at AHLA, so very excited to have her on today's podcast. Today's podcast is brought to you by the American Health Law Association's Fraud and Abuse Practice Group. I currently chair the PG, and our mission is to advance healthcare fraud and abuse and compliance issues, to bring our members and help them to stay informed about these issues as they develop. Our vice chairs are doing a great job of developing webinars, publications, and other content to educate our members on important compliance developments and enforcement trends across the healthcare industry. In many ways, this podcast today, this video podcast, is a preview to our practice group's year in review webinar that currently is slated for Wednesday, January 10th, I think in the afternoon from 2 to 3:30 p.m. Eastern. So please consider registering for that. Laura will be one of the panelists on that webinar. That's likely going to be moderated by one of our practice group vice chairs, Kristen Carter from Johns Hopkins. So again, a preview, but lots to talk about today. And Laura, before we get started with the back and forth questions, could you please introduce yourself?
Sure. Thanks, Joe. And thanks so much for the opportunity to be here with you presenting on this podcast. I'm really excited to be here. And thanks to AHLA as well. So I've been practicing in healthcare fraud and abuse for over 25 years. I'm currently a partner in the healthcare life sciences practice at Jones Day in the Washington, D.C. office. Earlier in my career, I spent about 5 years at the Department of Justice investigating and litigating False Claims Act cases that related to healthcare and life sciences. And then since leaving DOJ a long time ago now, I've been focusing my practice primarily on defending a wide variety of types of healthcare providers and suppliers, as well as pharmaceutical and medical device manufacturers against government investigations brought by the Department of Justice, including various U.S. attorneys' offices, as well as state AGs and also HHS OIG. On the flip side, I also devote a lot of my time to providing fraud and abuse regulatory and compliance advice to those same types of clients, with the goal of trying to keep them from becoming, from coming into the crosshairs of a government investigation.
Great, thanks, Laura. And I'm Joe Wolfe. I chair the AHLA Fraud and Abuse Practice Group. And I'm also a shareholder with Hall Render. My practice includes being the leader of the healthcare regulatory practice group at Hall Render. I also focus my day-to-day efforts on Stark law compliance, anti-kickback compliance, physician compensation arrangements, along a kind of a continuum from the development of contracting and compensation process through the development of models, compliance issues related to implementation, self-disclosures, and defensibility issues as well. And very excited to have Laura on today's podcast. I think now we're going to get into some of the back and forth on issues. I wanted to set the stage a bit. And for anyone listening, we're going to have the webinar, year in review webinar in January. Laura's going to be a panelist on that. I always encourage people to find the year in review slide deck if you can. Bob Homchek always does a wonderful job at the Fraud and Compliance Forum. I think this year, Laura, you were part of the topic team that put that package together. Others, and Gavin Keene, Brian Rourke, Brad Robertson, and just some really strong work. So if you can find that, also it always does a good job of showing what's happened over the past year. Going back to the book first, and I would say kind of broadly, I think we can all agree that fraud and abuse continues to be an area of focus within healthcare. It's a very busy area. Just going back to Laura's book, and the book this year, I believe, was a supplement, and correct me if I'm wrong here, Laura, to your AHLA book title, Legal Issues in Healthcare Fraud and Abuse. I think that was the 5th edition, was published back in 2020. And your book does a really good job of highlighting some of the big items we're seeing in the industry. We've seen some big changes to the regulations and guidance in the fraud and abuse space. I'd say especially since that big overhaul we had back in 2021. We're also seeing some different enforcement agencies continuing to actively enforce healthcare fraud and abuse laws as well. That book, Laura's supplement, does a good job of hitting on a lot of trends we're seeing. Things like federal agencies aggressively pursuing individuals and entities for potential violations of these laws, including, and this is going to be an area we're going to see continuing to unfold, is actions related to the COVID-19 pandemic. Also, the DOJ being active in pursuing healthcare providers in the life sciences and manufacturing space for violations of the False Claims Act. Those cases have involved a variety of conduct. We're still seeing whistleblower activity. Whistleblowers, of course, are always a big part of and active in bringing cases forward. They're pursuing those cases even when the government just declines to intervene in them. The OIG and CMS, again, finalized, I previewed this before, those additions and revisions to the regulations under anti-kickback and Stark. All of us working in this space are continuing to evaluate those rule changes. We're applying them I'm dealing with this a lot, applying them in new situations as issues come up, but also plugging them into self-disclosures, looking for ways to continue to educate our clients and bring forward those rules to help with initiatives and opportunities going forward. The book mentions those special fraud alerts. One, in case, is that recent fraud alert discussing skepticism around in-person speaking programs and warning healthcare practitioners of the risks of entering into arrangements with purported telemedicine companies. And then also the OIG continuing to issue advisory opinions to a range of entities. We just saw a couple of those come out more recently. And it's nice to see that Fraud and Abuse Practice Group has provided content on, how to seek an advisory opinion, what that process looks like, and it's good to see healthcare organizations are still seeking that guidance proactively. So, Laura, your book and that supplement really unpacks many of these changes, and I think what the anticipated impact of some of these rule changes will be going forward, both relevant to what's gone on in 2023 and what we need to see in 2024. So thanks so much for putting that together. Thanks for being on today's podcast, and I'm really excited to have you. Kind of jumping into the back and forth questions, Laura, of course, the super value case is getting a ton of attention, has gotten a ton of attention this year. Could you talk about that case and why it's so important, why it's gotten so much attention?
Absolutely. So the super value case, which was, we're referring to a recent Supreme Court decision that came down this year. So that particular case addressed scienter, which is the mental state required under the False Claims Act to trigger a violation. So under the False Claims Act, in order to be found liable, you have to have not only submitted a claim that was false, but you had to have done so either knowingly, as in having actual knowledge, or with reckless disregard or deliberate ignorance of the falsity of the claim. And so in recent years, a number of circuit courts have held that the scienter standard that was adopted by the Supreme Court in a completely unrelated case called Safeco Insurance Company of America versus Burr back in 2007, which was a fair credit reporting case, courts have found that that Safeco standard also applies to the False Claims Act with respect to the interpretation of scienter, what scienter is required. What Safeco held, and again, in the Fair Credit Reporting Act context, Safeco held that a defendant cannot have acted with the requisite scienter, i.e. with knowledge, if it acted consistently with an objectively reasonable interpretation of its obligations under the law. So when does this come up? This comes up in situations where the now defendant in an FCA case at the time, before they submitted the claims, were wrestling with, well, what exactly is the requirement here? There's some ambiguity around what a requirement is, and the defendant chooses one interpretation of the requirement, but there are other interpretations possible. And later on, the government says that it adopts a different interpretation and that the defendant did it wrong. And not only did the defendant do it wrong, but they did it knowingly. They at least should have known or acted with reckless disregard or deliberate ignorance. And so this Safeco standard has been invoked by a number of defense counsel over the years to try to address this kind of situation. And what was significant about Safeco, and a little different than a lot of other False Claims Act scienter decisions, was that in Safeco, the court had basically said, we don't care what the defendant was thinking. As a matter of law, they cannot have acted with the requisite scienter. They cannot have acted knowingly if they acted consistent with an objectively reasonable interpretation of their obligations under the law. So we don't even look to their intent. We just look to, was that a objectively reasonable interpretation? Did they act consistent with it? If so, there cannot be scienter under in that case the Fair Credit Reporting Act, but a lot of arguments that it applies to the False Claims Act as well. So this idea had been bubbling around for a while, since 2007. It had been starting to gain some traction with circuit courts. And in the case United States ex rel. Schutte, S-C-H-U-T-T-E versus SuperValue, the Seventh Circuit had joined 4 prior circuits in holding that this Safeco standard applied with equal force to the False Claims Act scienter provision, and they granted summary judgment for the defendant. So the SuperValue case involved Medicaid drug pricing. The question was whether that pharmacy retailer had reported appropriately its usual and customary pricing to Medicaid. The allegation was that they had violated the False Claims Act because they had reported their retail cash prices as being their usual and customary prices, whereas instead they should have reported the lower amounts that they were charging certain qualifying customers under their discount program, that those discounted prices are what actually should have been the usual and customary prices. And all of that, of course, then drives what Medicaid reimburses. So the district court found, and the Seventh Circuit affirmed, that they should have reported that lower discount price as part of the usual and customary. But the Seventh Circuit said, notwithstanding that, Seventh Circuit focused then on, well, the fact that they thought the guidance on what they were actually supposed to report wasn't clear, and certainly wasn't clear at the time at which they were submitting their claim. And the Seventh Circuit said an objectively reasonable person could have thought that their interpretation was correct. And since there had been no authoritative guidance to the contrary at that point in time, they said, as a matter of law, SuperValue could not have acted with the actual knowledge, reckless disregard, or deliberate ignorance required under the False Claims Act. The Supreme Court considered that and unanimously disagreed with it and overturned the Seventh Circuit decision. The Supreme Court focused on, instead of saying, as a matter of law, if it's confusing and you acted consistent with an objectively reasonable standard, as a matter of law, you can't have violated the statute. They said, no. We're going to look at what the defendant actually was thinking at the time. We're going to take that subjective approach, not an objective approach. And we're going to look at their thinking, and a defendant can be liable if one of 3 things. Number 1, if they actually knew that their conduct was unlawful. Number 2, if they were aware of a substantial risk of unlawfulness and they intentionally avoided learning about the conduct legality, which sounds a lot like reckless disregard, deliberate ignorance. Or number 3, if they were aware of such a substantial and unjustifiable risk but submitted the claims anyway. That one I sort of wrestle with. I'm not really sure what that third one means, and there's probably going to be litigation now about what it means to take an unjustifiable risk. But I think the key takeaways, regardless of what exactly that language does or doesn't mean, I think there's some key takeaways. Number 1, if there are multiple possible interpretations of a law or regulations, that is not enough to protect you, a defendant, a potential defendant in the future, right, a provider, a manufacturer, against claims that you committed fraud by adopting one of those multiple interpretations. The government and the courts are going to hold you to a duty to try to find out which one of those interpretations was correct and to act consistently with that correct interpretation. Number two, unfortunately, the decision doesn't give any guidance about what you're supposed to do when you still can't get a clear answer about which was correct. And that, which is where we find our clients. I'm sure, Joe, you find this all the time too. Healthcare providers and pharma and device manufacturers are constantly trying to figure out what exactly is it that we're supposed to be doing. And that's why the healthcare lawyers stay busy, right? But we don't always have a clear answer. In fact, we often don't have a very clear answer on those difficult questions. So there's no clear guidance about what exactly you're supposed to do when that happens. So given that situation, our recommendation has been, and I think this is kind of what providers are going to need to do, when you're faced with unclear guidance and there's no clear answers to what you're supposed to do, I think it's a really good idea to document which approach you're taking and why you're taking it, why you think this interpretation makes more sense than the others, and then, of course, act consistently with this interpretation so that if and when the government comes knocking later, there's not a question, well, there's a question, but you can respond to the question of what were you thinking with, here's exactly what we were thinking, and here's exactly why we thought that we were justified in taking that approach. Is it a satisfactory answer? No, it's not. But I think that's where we're left right now.
Thanks, Laura. And I really appreciate that, especially the end. That's the practical guidance there on that case and what providers can do. Let's go beyond super value, and obviously this question's a big lift. What do you see as some of the key trends and developments in healthcare fraud and abuse in 2023, and as we think about going forward?
Sure, there are so many, and we could easily spend a much longer time, but we're going to keep this fairly limited. So I'm just going to hit on a few highlights, but there's certainly, for those who are interested, come back in January for the webinar, because we'll be spending significantly more time talking about these things, and we're still not going to hit on absolutely everything, I'm sure. So first of all, in the case, it's been a really interesting year for case law. The Supreme Court considered not only the super value case, but also a different case, Polanski versus Executive Health Resources. That case teed up the question of whether and when DOJ can seek dismissal of a False Claims Act case even over a relator's objection. So this arises sometimes, relator, whistleblower, same word, same concept, brings a case, DOJ investigates and decides whether to either intervene in the case, i.e. take over the litigation and lead the litigation, or to decline, i.e. to stand back, in which case the whistleblower can move forward if they want to. There are some situations where DOJ does not want to take over the litigation for whatever reason, lets the whistleblower go forward, but decides that the case shouldn't go forward. DOJ decides the case shouldn't go forward for whatever reason. A lot of times, it's a combination of they don't really see a lot of merit in the case, and they see a lot of headache for themselves, a lot of expense for themselves, other sorts of litigation risk. Whatever the reasoning, they don't always share all of it, probably don't ever share all of it, but they have their reasons sometimes for wanting to dismiss the case. So occasionally, it's not that frequent, but occasionally they will come in and try to dismiss the case. And so there's been a question for a number of years, particularly the last 4 or 5 years since Michael Granston issued the Granston memo talking about giving guidance internally for DOJ as to what they should consider when they're thinking about seeking to dismiss. Since that time, there's been a little bit of an uptick in the number of times that DOJ sought to dismiss, and there's been a huge uptick in defense counsel talking about this issue. And also in courts considering it, there was a split among the circuits, and the Supreme Court took a very unexciting position, but unexciting in the sense that it's not particularly sexy. It's pretty straight down the middle. They basically say DOJ gets to seek dismissal of a False Claims Act case, even over the relator's objection, so long as the DOJ intervened at some point in the litigation. They don't need to have done it initially. They can have declined and then later sought to intervene. But as long as they've intervened, then they're a party. They're the real party in interest. They get to seek to decline it. And the courts are going to be, incredibly deferential to that. So it's now easier for them to dismiss cases. Which is kind of interesting and maybe kind of helpful in a very few cases. What I think is going to be more interesting, though, going down the road, and I'm already sort of looking forward to 2024 here, is the opinions by Justices Thomas and Kavanaugh. They both separately noted the existence of substantial argument that the qui tam provisions are inconsistent with and unconstitutional under Article 2 of the Constitution, and that private relators cannot represent the United States' interests in litigation. And so I think we are already seeing that argument being raised in some existing litigation, and I think we're going to see that argument raised and teed up pretty quickly. The Supreme Court is, at least they have already triggered the indicated that they're interested in taking on that question. So I think it's just a matter of time, and probably a fairly short amount of time before that gets to the Supreme Court. So that piece of it's interesting. We also saw some interesting developments in cases about alleged anti-kickback statute and False Claims Act violations in the same case. So situations where an alleged anti-kickback statute violation gives rise to liability under the False Claims Act. So under the revisions to the anti-kickback statute back in 2010 under the Affordable Care Act, there's new language new 13 years ago, that says a claim that includes items or services resulting from a violation of this section in the anti-kickback statute constitutes a false or fraudulent claim for purposes of the False Claims Act. So DOJ has consistently argued that resulting from language just means downstream from. That if there's a kickback to a person, then every item or service that's billed for anybody referred by that person is per se false or fraudulent under the False Claims Act. Well, that completely reads out the language resulting from, which DOJ and a number of courts have justified by looking to the legislative history and saying, well, if we look to see what Congress was trying to do, they were trying to make it easier for these False Claims Act cases to be brought predicated on anti-kickback statute violations. And so that's what that must mean. And I certainly agree that that is what was going on at the time that they adopted that language, but it kind of ignores the plain language of the statute. And I know I learned in law school that you're supposed to look first at the plain language of the statute, and then if it's not clear, then you look at legislative intent. But I have found in my discussions with DOJ, they tend to just sort of leapfrog over that plain language issue, as many of the courts have as well. But more of the courts now are focusing on that language and saying, well, no, it's got to mean something. And so most recently, both the Sixth and the Eighth Circuits have said, we need to look at the plain language. We're looking at that, and that resulting from means you need but for causation, that but for those kickbacks, the false claims those claims would not have been submitted in order for those claims to be false. DOJ does not agree with that approach. It is now being teed up as well currently in the First Circuit, where the District of Massachusetts, two different judges have taken two different positions within the space of a couple months. District of Massachusetts, of course, is where Boston is. Boston U.S. Attorney's Office is very active with False Claims Act cases and kickback cases in particular. So even though that's just one circuit, I think that's going to have an outsized impact, whichever way it goes, on what happens across the country and what happens in False Claims Act cases. But so those are all case law. Couple other things a little more briefly. I'll note that both DOJ and HHS OIG have been issuing more guidance this year. The DOJ's criminal division, so not the False Claims Act post, but the criminal division has issued guidance on self-disclosures, saying that there's a presumption that they will decline to take criminal action and that they'll impose lower fines in cases of self-disclosure. Of course, that doesn't mean you get off with scot-free, because of course you're paying a fine. There will be a fine. They're just saying they won't aggressively pursue you as an open case. They also have said that they're providing a safe harbor for self-disclosing violations that are found in situations where in merger and acquisition situations. So the safe harbor, which is actually supposed to apply not just to the criminal division, but across DOJ, according to their policy statement, so that there's a presumption that DOJ is going to decline to take enforcement action against a company that has acquired another company where they're making the disclosure about the acquired company, so long as it was a bona fide arm's length M&A transaction, and so long as the acquiring company, number one, voluntarily self-discloses the suspected misconduct at the acquired entity within 6 months of the date of the deal closing, whether the conduct was discovered before or after the acquisition. Number two, so long as the acquiring company cooperates with any ensuing DOJ investigation, that's pretty standard. And number three, so long as they fully remediate the misconduct within a year of the closing date, also pretty standard, and they pay any applicable restitution or disgorgement. So I think that's kind of a big deal, and that potentially applies to the civil as well as criminal folks. And then HHS OIG, completely separate from all that, recently issued a new general compliance guidance document. It doesn't really change things very much, but I think it's a very helpful resource. It pulls together and refreshes and updates a lot of OIG's prior guidance. It provides links to the earlier guidance, and they say that they're going to be coming out with new industry-specific guidance in the coming year. So I do, even though that really isn't a game changer in any way, it is a very helpful document, and it does talk about a couple things that, like risk assessments that have been in CIAs for a while, but that they're now officially saying everybody should be doing those in their compliance programs. Things like tracking financial arrangements with referral sources, again, also in CIAs for a long time. Now they're saying should be a general compliance thing. And also they do emphasize a focus on private equity. They specifically call out private equity and the need to, that they think that there's some potential risk from a compliance perspective there. So worth a read. And then with respect to enforcement trends, a lot of it's been a continuation of what happened last year and will probably happen next year, but we continue to see a lot of focus by DOJ on individual liability and also on the potential liability of investors, including private equity firms, in both False Claims Act cases as well as, of course, criminal cases. Criminal cases have always focused on individuals largely, but we're seeing a lot of that focus still in FCA cases. More cases involving COVID-related fraud. And I will note on that, though, a lot of these COVID cases have been brought by DOJ directly rather than by whistleblowers. My hunch as to why is because a lot of these aren't that huge in dollars, so probably not worth it for whistleblowers to bring, and or whistleblowers just don't know about them. But DOJ is finding these and bringing a lot of these directly. So along with that, we're seeing an uptick in the number of cases that DOJ is bringing directly rather than just relying on the qui-tam provision. And then there's also been a lot of there's some focus on telefraud, which continues to be the source of a lot of cases. Still not a lot in what I think of as real telehealth fraud, but I think that over time we will be seeing probably an increase in focus on cases there. Certainly OIG has been talking a lot about telehealth and how to comply with it and things to look out for in telehealth, and they've talked about the importance of it. And I know that a lot of our telehealth clients have been really focusing on making sure that they're buttoned up and doing things the right way in anticipation of anticipated enforcement. But right now, most of that focus has been on telefraud, which also is related to a continued focus on kickbacks. But Joe, let me ask you, so with kickbacks as sort of a transition, I know you do a lot of work in the Stark space. So what kind of compliance issues and trends are you seeing?
Thanks, Laura. I do a lot of work in the Stark space. Kind of looking back at this past year, there's been a lot of development. I would say when we had the end of the public health emergency, there was some immediate attention on what healthcare organizations did during the public health emergency. Many conducted a Stark or compliance type audit so they could determine, what kind of action they'd taken if they were relying on a waiver, including like a Stark COVID-19 waiver, had they appropriately documented that. The test, of course, has been whether you utilize that arrangement to achieve a COVID-19 purpose. That was a big area early on. There's been an ongoing focus on understanding and continuing to evaluate the recent Stark guidance. We have seen more flexibility in the recent rules around the writing and getting your signatures and the new de minimis exception for payments under $5,700, for example. But healthcare organizations are using those in application. Some of the recent guidance from that rulemaking, I've seen that apply in the self-disclosure context where the government came back and said, look, could you apply this concept to this arrangement that is already in the self-disclosure protocol? Might that change the analysis? So that was interesting to see that play out. The rule changes also created, I'd say, a bit more certainty around the volume and value standard. I've seen that be impactful to how arrangements are being analyzed, more guidance on fair market value and commercial reasonableness. That continues to be an area that I would say is challenging. The government did give us guidance on extenuating circumstances being relevant to the analysis. And I think with financial pressures in the healthcare industry and healthcare organizations trying to continue to recruit and build their physician enterprise, that they're continuing to work through those fair market value and commercial reasonableness issues. There have been some data issues that have impacted physician compensation in particular, how survey data was collected and how it was impacted by COVID-19, how it was impacted by changes to the physician fee schedule in recent years has led to some destabilizing impact in some of the survey data. And so healthcare organizations have had to work through that. When we think about individual arrangements, especially arrangements where physicians and APPs are working collaboratively, there's been more attention in that space as well. There was a recent advisory opinion on that issue. It was a focus, an area of discussion at the most recent AHLA Fraud and Compliance Forum. So that's been an area that I've seen healthcare organizations looking at. How are physicians and advanced practice providers working together? Some of the issues around maybe some billing guidance that may be changing, where in a shared care situation, the provider doing 51% of the time-based activity may be where the bill falls. Healthcare organizations have been trying to get their arms around that change in the guidance. We had a new exception for physician wellness programs that went into the statute this past year. I think that's a new opportunity for healthcare organizations to develop wellness programs for their physicians. And also the new value-based rules. I've seen a lot of movement in this area over the past year. Healthcare organizations have had a chance to examine and educate their business leaders on how they might use the new value-based enterprise rules as an opportunity to advance their care models. So that's an area that I've seen in the Stark space that's been getting lots of attention, and I've been doing a lot of work in that space. We've had a number of enforcement actions along the Stark line of in the Stark space, and I think that the allegations are often, of course, blended together. But many of the recurring Stark issues we're still seeing those emerge in the cases. There have been a number of large cases over the last year in the ranges of 45, 50, 60, 70 million. So those are, and more. And so some of those are in the settlement phase, some are through self-disclosure. I'm seeing, that's kind of above the radar, what we're seeing, in the industry that's public. I do think that we're seeing an uptick in investigations as well. That's not as public. And I think we'll continue to see that. I think there's going to be emerging CIDs, and we're just seeing an uptick in that kind of activity. Beyond that, the government, especially in the settlement space, if we think about the self-disclosure protocol, CMS published some recent summary data on that, and I think it does show like how many self-disclosures are kind of going through the pipeline. If you look back to 2021 and to 2022, we saw 27 self-disclosures in 2021, up to 104 in 2022. I'm interested to see as the data is released for this year. I'm guessing we're going to continue to see a very large number of those self-disclosures being moved forward. And then lastly, value-based care models. I alluded to it earlier. but I think healthcare organizations are starting to get their eyes around this idea that if we create or we can use a value-based enterprise model uh, in order to develop incentives that achieve some kind of value-based purpose, care coordination, quality, or cost containment, and that the government made those rules largely flexible, and there just may be a lot of opportunity to work in get and advance models in that space. And so excited to see. I do think that in the post-COVID world, we have seen a bit of a return to re-examining internal processes and trying to achieve process improvement, as well as we've seen a bit more stability this past year. And so I think that's something that will unfold in 2024 as well, just kind of revisiting how healthcare organizations are handling the contracting process and how they set compensation, how they do financial analysis, and how they conduct audits. So they're going to kind of examine themselves a bit. I saw that happening in 2023. So, Laura, thanks for that question. As we look to 2024, if you had your kind of crystal ball, what do you see happening? What do you see as the big areas as we look to the next year?
So there's so much going on, but I think in my world, really a continuation of a lot of what I was talking about before. I think we are going to see more litigation on that question of the causal link between alleged kickback violations and false claims under the False Claims Act. Does it get up to the Supreme Court next year? Don't know about that timing wise, but I think it continues its pathway to the Supreme Court next year, probably. I think we're going to see litigation on this question of whether the False Claims Act's qui tam provisions are constitutional, and I'm curious to see what flavor that takes and sort of where that goes. I don't think that would knock out the whole False Claims Act by any means, but maybe that would mean that relators can't continue on their own if DOJ declines. I don't know. It'd be interesting to see what judges and ultimately the justices do with that. I think we're going to continue seeing lots and lots of enforcement cases, like you were saying, continued CIDs, continued subpoenas in some districts. And I think some of those are going to continue to relate to COVID-19, right? It always takes a few years for, stuff happens, and then it takes a few years for it to percolate, for DOJ to figure out what the allegations may be, issue subpoenas, start investigating, and then for things to become public. So I think we're going to be seeing more and more there, and a continuation of kickback cases. Those seem to now be, at one point they were just a small subsection of False Claims Act cases. And it seems like now they are a huge proportion of False Claims Act cases being brought. So how about you? What do you see coming down the pike?
I feel like I'm reiterating what you're saying. I'll just hit a couple. I think, again, more healthcare investigations from different agencies. I think that's happening and is going to happen. I hit on it before. I think more value-based care, value-based enterprise type of arrangements. We've both, I think, mentioned it. Continued attention on private equity. I've heard this from a number of sources. There was a recent announcement of that Chuck Grassley and Sheldon Whitehouse are launching an investigation a bipartisan investigation into private equity ownership in healthcare. And so it'll be interesting to see that unfold over the next year. As I mentioned before, continued attention on process improvement. And I do think we will see a return to some projects that healthcare organizations were exploring prior to the pandemic. We've seen movement in the transaction space, obviously a focus on antitrust and whether or not competition is being advanced or not. But I think we're going to continue to see an activity from a deal standpoint, a contracting standpoint. Healthcare organizations try to find ways to be more collaborative in ways that align with the fraud and abuse laws. So that's what I see coming up. And I think we've included a lot of nuggets as to what's going on and what's going forward throughout this. And so I'm really excited, Laura, to see the webinar in January where you dive in more. Just one final question for you. I'll just give you a chance. Do you have any final thoughts for the podcast audience before we wrap up?
I think my final thought to share is they've all heard so much from both of us about all this different activity that's going on in the fraud and abuse space, in enforcement and with respect to other developments that could ultimately affect enforcement, things to think about, and yet there's still so much unknown, or not so much unknown. Unknown probably isn't quite the right word, but there is still so much gray area in healthcare rules and regulations generally, and screwing up on, even if they're not fraud and abuse provisions, screwing up on those can lead to a fraud and abuse problem. I know Congress and CMS really, I think they do try to give clear rules. But the problem is once you take those rules and you start applying them to real everyday life, it's not as clear as to exactly what you're supposed to do because they can't take into account for everything. So I think our clients are going to continue to struggle in various aspects of are we supposed to do this? What exactly are we supposed to do? What's in, what's out? And I think, I think even in value-based arrangements, trying to move forward into that, I think there's been some hesitancy by clients to move into that because they're not entirely sure what it means that they can do, and maybe the rules seem overly onerous, but I think there's also just an element of not being sure. And so I think for all of uncertainty, which all of our clients face day in and day out, I would just give the advice of, figure out what you think the rules are and then document them and make sure, and for posterity, so that you can go back and revisit that when your business people say a year from now, exactly why are we doing it this way? But also so that if you get a subpoena or a CID about something 2 years from now, 3 years from now, the decision makers may not be there anymore. And so and even if they are, good chance they'll have forgotten exactly what they were thinking at the time. So I think it's particularly after the super value decision, I think that really just underscored the importance of when you're in a gray area, make your decision, get good advice, get input, but then once you've got that input from your lawyers and your compliance people, document the decision you're making and why you're making it and save that, because that's going to be potentially important for you to be able to defend yourself later.
Yeah, that's all great advice, Laura. I would only, I think that's why we all have, it's a challenge in this area. And I think why education is so important. This would not be the year I would take off from staying in the now and staying educated if you work in this space. And I think it's important to develop education internally to continuously remind people of these rules, because they're very easy to kind of lose some of that knowledge over time, and as we've seen transition in healthcare organizations over in recent years. So education is critically important, and thanks to everyone for listening into this podcast as an opportunity to stay educated. Thank you so much for your time today. Thanks to all of you that tuned into our podcast. Thanks to Laura Laemmle-Weidenfeld for being our guest today. Please look for our other podcasts. We've recorded a number of recently that have been issued, one on that super value case, one on False Claims Act settlement trends, a recent podcast on financial analysis, and we have more coming in the upcoming months. We're always looking for volunteers within the healthcare fraud and abuse practice group. Please reach out to me if you'd like to get involved, or any of our vice chairs. Reach out to me on LinkedIn, and tune into future podcasts in this space. Thanks for tuning in, and have a great afternoon.
Thanks, Joe. Thanks for listening.